Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have our firm attorney, Gina Bonomini, to talk about everything you need to know involving third-party custody and visitation issues. Hey, Gina, how you doing this morning?
I'm doing great. Thank you for the introduction, Steve.
Well, thank you. And thank you for joining on this, because as we were talking, this is a complicated, difficult, and frustrating issue
Yes, it is
for
very,
people.
yeah, it's very fact
Really.
specific too.
And that's what drives it, like you said. So let's
Yes,
kind of just start with, why it can be so difficult. I know that, there was a Supreme Court case that came down, or several that came down that talk about, you know, if parents are presumed to be good parents. And well, maybe you can talk just a little bit about kind of why it's so difficult to understand.
well, because it's voiced as a presumption, and I think that's what throws people off. It's a presumption that natural parents, or legal parents, I should say, act in the best interest of their own children. And basically, that means that a parent isn't necessarily unfit and isn't making wise decisions for their children. It's just that the totality of the circumstances, there's something that's not quite right, and the children need more than just their parents involved in their life. A lot of times it happens after divorces, separations, where there's domestic violence, where kids have been put into foster care, and DHS has removed the children, and then they kind of back off a little bit if there's a third party, because DHS also places them with third parties. And
Yeah.
basically, a lot of times, 109, 119 will kind of, for example, nobody has custody of the child, but the child's just 3 months old, or actually, this was a case I had, 3 weeks old, and the mother had three other children, and the in-laws they weren't married, but the in-laws were basically taking care of the infant and would babysit the older three children. But the mother would pick up the older three children and leave the infant behind.
Oh my gosh.
The mother was not their daughter. The
Right.
father was their son. And he was okay with that. I mean, yeah. And so it went on for like 3 years. So finally, they were tired of being threatened all the time with losing basically physical custody of the child. So they ended up filing. And there was no prior custody case of any kind in the court system. So it went straight to the petition.
Oh my
So
God.
there's, yeah. So it's very fact based on that one.
Yeah.
And that one actually ended up at the appeals court. The grandparents won custody,
Oh, I love it.
and they were trying to decide what constitutes day to day, because there was no cases that discussed day to day,
Yeah.
except for there was a woman that had her grandchild 3 to 4 days out of 7, and that was not enough to basically say day to day. So you knew it needed to be more than 3 or 4, but you didn't know if it had to be 7. And my case came down as 5 to 6.
Yeah.
So
It,
5 days, so it's like 4 and 5 is like you're better off if you have the child 5 to 6 days a week.
yep.
And so that was the biggest hurdle, was because your parent-child relationship, well, there's two type of relationships you have to have. So basically, you have to be a third party, and a third party is really broad. It's anybody that's had a certain relationship with a child. Um, so, because before you can overcome the presumption, you have to have a certain relationship with the child.
Right.
One is a parent-child relationship, which has to be within the 6 months of filing. Now, they say 5 to 6 days a week constitutes a parent-child relationship if you've been giving them basically their food, taking care of them medically, basically being a parent to them, psychological parent, not an act,
Right.
acting like a parent, taking care of them, disciplining them, taking them to school, their doctor's appointments. I mean, you are basically taking care of that child 24/7, except it can be 5 to 6 days a week now.
Right. Yeah.
Have to be. And
It,
then,
it
Go
I
ahead.
was just going to say it makes sense that the relationship has to be there, and like you said, it's part of the problem can be the wording isn't necessarily specific, and so one person's child parent relationship may be another person's not, and you got to know the judges almost to do that.
Yeah. Well, we also had a custody evaluator in our case, which basically said it would be psychologically detrimental because what happened was when after the grandparents filed, the mother took the child back. So the
Oh,
child started acting like he had three older brothers that, and this is all public record. I mean, you can get the video, I mean, the audio if you really wanted to, but they had issues. I mean, the mother had issues,
yeah.
the children had issues, and she'd ended up having another baby girl with this guy, with another guy, and so she appealed it. The grandparents got custody because the custody evaluator said it would be psychologically detrimental to the child for the grandparents not to have custody because his personality started changing when she had him full time. The mother had him full time to start acting out like the other brothers, hitting himself in the head, threatening to kill himself, all these behaviors that shock you coming from a 3 or 4 year old because he was only like 4 at the time of the trial, and we started when he was 3. So, that was kind of scary. But so this case had a lot of stuff
Yeah.
that I had anyway that went to the appeals court to get the 5 to 6 days because that's what the mother argued the most was that my clients didn't have him enough to do day to day because she didn't have him all the time. They didn't have him every day, but they had him enough that it averaged 5 to 6 days a week. They did apply for, you know how you can get babysitting subsidies through the state.
Yeah.
So they did apply for that to help offset the cost of having the 4 children almost every day during the week and then having the other child almost 5 to 6 days a week. 24/7, 24 around the clock. I mean, he spent the nights there. They had a bedroom set up for him. He had his own clothes. I mean, he had a bedroom there. I mean, the other kids didn't because they only came during the day. So she tried to use that against him. They stopped subsidizing when they realized they really couldn't because he was in their custody. So they only got the subsidy at one point for only the 3 boys who were there during the day. Not that it changed much.
Yeah.
So they stopped receiving the babysitting subsidy from the state, not realizing they shouldn't have been doing it for the child that was living with them.
Right.
I mean, because if you think about it, 5 to 6 days a week means he was only spending a day with his parents.
Yeah.
So that's a child parent relationship.
Yeah, exactly. Is that enough? I mean, let's say I've established I have a parent-child
But
relationship.
yeah,
Is
they
that enough?
basically, it's emotional type. Well, yeah, because they were supplying everything, clothing, food, education. Well, he wasn't old enough, but education, they were doing everything. They were teaching him his colors and basically homeschooling preschooler. And he viewed them as his parents. I mean, he calls them grandma and papa and grandma, but it didn't change the fact. Actually, he started calling her mom early on, and they said, well, no, call me this. I'm grandma, but yeah, I mean, they fed him, clothed him. They did everything a parent would do for a child. I mean, they're the ones that bought most of his clothes.
Yeah. No. Yeah.
Yeah, I mean, they were clothing and feeding him just like any parent would. Took him to his doctor's appointments. And that's unusual too. I mean, so yeah, I mean, it was a lot.
The once you've established that you have a parent-child relationship, um, is there anything else you need to prove? I mean, is the court just going to say, oh, because you've established that, you get it?
No, there's factors that the court looks at, and they look at the totality of the factors. So with a parent-child relationship, you're in a better position than if you have what's the other one, which is an ongoing emotional attachment, like most grandparents have with their
Right.
grandchildren, that aren't living with them on a day-to-day basis. Excuse me. And that has to be for at least a year. So for a third party like me, let's say I have a best friend and I see her child all the time, and we've bonded, let's say, and it's been over a year, and then I've had this ongoing relationship with this child for over a year. She gets into drugs or something. So then I file for custody for visitation, because I still want to be in the child's life, but she's tried to cut me out of the child's life. So it'd be an ongoing personal relationship with the child. But the evidence, okay, if you notice that when you're looking through the stuff, the parent child, it's just a preponderance of the evidence.
Right.
If you want to get custody or guardianship.
Right.
Where it's clear and convincing evidence, which is actually a higher standard if you're going for visitation or contract rights. So as long as you have one type of those relationships. Now, for custody, you have to have a parent-child relationship, and for guardianship, you have to have that's weird. You have to prove a closer relationship, but like at a lower standard. But for visitation is because you're not necessarily interfering. You have to prove that you're not interfering with the parental relation. It's a little higher standard, I think, because you're just going over the objection of a parent and not necessarily, it's harder to get.
Yeah.
Visitation is really hard to get. Now I have gotten it for a grandparent, but that was a special, like I said, it was fact-based. You had two parents that were really low IQs. They were 70, near 70, 75 IQ. And she could have gotten custody, put it that way. If the grandmother wanted custody, she could have gotten custody. But she only wanted to stay in the children's life because they kept cutting her out. Right. So I did get her visitation, and that's really hard to get because you're going over the parents' wishes, basically. But the court found that the parents, it would be detrimental because she was the only steady person in their life, their most stable person in their lives, where their father and mother were not as stable. The mother wasn't at all. And she actually testified against her own daughter. It was really sad, actually. She didn't think the father should have custody, but the mother would have just neglected the children. So an ongoing personal relationship has to be for a year. It doesn't say that has to be within a year. See, this is where it's harder, because if you have an ongoing personal relationship for at least a year, there's not really a deadline to file. But for parent-child relationship, it has to be within 6 months of filing the petition. So you have to make sure you don't miss that.
Right.
So they make you do it quicker. Like, you can't avoid the child for a year and then file for child-parent relationship. You can do ongoing personal relationship, but you can't do. So your rights are a little different.
Yeah.
And then the standards are a little different. A lot of times, go ahead.
I was going to say, I'm wondering if you meet all of this, you've actually met it as either the grandparent or another third party. Does the parent need to also be found as not, being able to take care of their kid, or are there any issues beyond, does the judge look at the best interest of the kid?
They do eventually. It's like a three-part, it was what I would say. First, you have to prove the type of relationship you have with the child, which a parent-child relationship, if you look at all the appeals, are mostly around a parent-child relationship.
Yeah.
And if they've established that they had a child-parent relationship. So that's your first hurdle. It's normally the easiest hurdle to get over, even though most of the appeals court, because like I said, until my case came out for 5 to 6 days, we just knew you had to have more than 3. But somewhere between 3 and 7. Now we know it's at least 5. If you have them 5 to 7 days a week, you pretty much can prove a child-parent relationship. If you're feeding them, you're clothing them, you're acting like a parent to them, you're disciplining them, rewarding them, basically everything a parent should be doing.
Yes.
With children. You're establishing that relationship as a parent, and they look to you as a parent. Because it's, you kind of know, if you see children out and about, who they look to, so once you establish that, then there's some factors in the 109, 119. depending on the factors are kind of the same but different. A couple things are different. And like I said, it's either preponderance of the evidence, excuse me, or clear and convincing. And if you go to 109, 119, which I had open here somewhere, I'll go down here. Basically, now most people do not put the word guardianship in here, and it is in there. And I'm just gonna make a little side note. Guardianship is different because it goes under 120 ORS 125. So you can get guardianship. It doesn't get to 109, 119. The factors come into play the minute the parent objects. You have to go into 109, 119. So that's the issue, which a lot of judges don't do it. So unless you're with a good attorney who knows 109 and 119, then you have to turn it into a 109, 119 because it says guardianship under 109, 119. And you're a third, So I actually had a father who was trying to get his child back from a stepfather. And no offense against his attorney, but his attorney didn't immediately object and turn it into a 109, 119 hearing. Because the person who pled for the guardianship didn't plead 109, 119 until I did a motion to dismiss based on 109, 119, that the parent was acting in the best of, he hadn't overcome the presumption.
Yeah.
And I got the child back for the father, the bio father. So, you have to remember that when guardianship comes into play, that it's a parent-child relationship, and then you go to 109, 119. So
what you said, there was another hurdle though.
Yeah, well, so the second hurdle is, and I think there are the factors. And depending on whether or not you're going for custody or visitation, custody is the legal parent is unwilling or unable to care adequately for the child. So, sometimes they can, but you can still get guardianship or custody or guardianship. And then the next one is the petitioner is or recently has been the child's primary caretaker. When I say petitioner, I'm talking third party. Yeah. That the third party has been, right. And that's why, what's the child's primary caretaker? And that's when the 5th or 6th days come in. But you can also do it for visitation, which means at one point, you don't just have them like 4 hours a day, 2 days a week. And you can it's going to be hard to overcome because you weren't the child's primary caregiver. Right. But both people can be equally the caregiver. Like on one case that had 3 to 4 days, the child spent the night with her because the mother worked as a nurse and worked 24 hours, worked straight on call. But that wasn't a parent-child relationship. She didn't have her enough. It was an ongoing personal relationship because she had been the child's primary caregiver. The legal parent has unreasonably denied or limited contact between the child and the petitioner. And that's kind of the same for both custody and visitation. That one is. And basically, all of a sudden, you're like, let's say somebody has guardianship and you're the stepfather. Well, all of a sudden, that relationship's been okay the whole time. Let's say a grandparent has guardianship and they've been letting the stepfather come visit the child, and then all of a sudden they cut it off for no reason. That would be denying the contact. And so or limited it. You're seeing them every day, and all of a sudden they say, no, you can only see them every other weekend. You're like, well, wait a minute, I've been seeing them every day. I want to see them more. And then that kind of thing. And then I'm going to skip the next one, but the legal parent has fostered, encouraged, or consented to the relationship between the child and the third party. And that often is what gets you here in the first place, is everything was fine. Everything's going along fine. Whatever happens, drugs happen, they meet somebody new and the person's a jerk or talks them into saying, why are you letting them have the child so much? Kind of thing. Things happen and the relationship breaks down between the adults. But yet they had fostered the relationship before.
Right.
So like if you were cut out of your child's life early on, they brought you back in and then they cut you out again, you might not get that one in your favor. But I think the most important one, and then, So for visitation and other factors, allowing visitation would not substantially interfere with the custodial relationship, which means you kind of have like a parenting plan, like a non-custodial parenting plan where you see them every other weekend. That's not going to really interfere with the parents, as long as you're cooperative in events and stuff. So the most important one that I find that you really have to have facts to back up is circumstances detrimental to the child exist if custody or visitation is denied. And I think that's the big one. The more you have facts in your favor, they go back to the natural parent. They're not dressed all the time. They go to school dirty. Their grades are dropping. They're psychologically acting out all of a sudden. They're angry all the time. The child changes. And the child isn't getting what they need. Like in my one grandparent visitation one, she was the only stable person in their lives. She was consistently and had a stable home. She used to be a teacher, so she could help them with their homework. She could do all that stuff where the parents couldn't. They would fail to do that stuff. So she really helped those children out. So the judge saw that and knew that if she wasn't in their life, they were going to fall through the cracks educationally, psychologically. She gave them a safe place. And then with my other grandparents, he knew who his parents were. He knew who mom and dad was, but his grandparents were mom and dad to him. He didn't call them mom and dad, but that's who they were. And he was such a young kid 3 weeks old, they started taking care of him on 5 to 6 days a week since he was 3 months. And he was 3.5 years old when we started the case, and he was 4 when we went to trial, 2.5 days of trial. And he's still with them today. They do a 6-4, 6-8. The mother has him for 6 days. My clients have him for 8, which has really helped. And they've gotten him help if he needs to get help, psychological help, but they're the custodial parents. For all intents and purposes, now, I know people don't really ask about it, but you can technically go after for child support. A third party can get child support. And it doesn't say that in there, but as the custodial parent under the child support laws, you can get child support. And we did ask for child support. They get the minimum, and they get $100 a month. That's the minimum. And, and sometimes they get it from the mother and sometimes they don't, and tax returns are great because the child support division goes after your taxes. If you file taxes and get a refund, they can catch up on their child support. So it's just, until you really talk to an attorney, you can file on your own, but it's really hard. And the one thing attorneys need to know is all you have to do is put the statute verbatim in your pleading, and you've pled it.
Yep.
And then, that's what the petition is all about. You can say how long, you have to say how long they've had the child, how often they've had the child, no matter which one you're doing. And you always plead in the alternative. If I go for custody, I always plead for visitation. Don't leave it out. There's no reason to. And like I said, you can put child support in there even if you don't need it. Yeah. Because it always comes down to a bargaining tool. Don't be afraid to ask. And I don't know why people think step parents don't establish a chair. Step parents are the ones that have a child-parent relationship really easily because they're in the house all the time. They're living with the kids, especially if the mother has custody and the father only has his visitation. I mean, it's not 50-50. Now, I haven't really done one of those yet where the children are on a 50, because nowadays you can get 50-50 custody and parenting time, not custody, parenting time really easily now because it's statutory. And the judge has to make findings not to give you 50-50. So I haven't seen any cases about that yet. So, and now I'm arguing against an attorney is you don't modify an old judgment because the person you're representing, the third party, is not a party to the judgment. So you can't modify it. You have to file a petition. Right. And you have to decide how to file the petition. If you file just a new case in a petition, you can do that. It doesn't say you can as long as the underlying case is closed and there's nothing open, nothing pending, which means there's no modification, and I just found out at least in Layton County, if you file a motion to intervene, you've now made it pending. So you have to decide before you file the motion to intervene if you want to do a whole new case.
Right.
Um,
is there a functioning sort of joint custody in this kind of a situation? And is it something that could be agreed to? It sounds like it needs to actually be changed by the court.
no, it does not have to be changed by the court. We have stipulated to when we were well, we did have a court ruling, but yes, you can stipulate to it. And what I did is there's no findings. You don't put that and that's, I had another attorney try to put that in, and I said no, the judge didn't make that finding that the parent didn't act in the best interest, because we agreed to visitation for the stepfather, yearly visitation, because the kid was over 6 and it was 2 different states. So one was on the East Coast and one was on the West Coast. It's a long story, but anyway, the natural father was on the East Coast and the stepfather was in Oregon. And so we agreed to visitation, and she tried to put that the presumption wasn't overcome or that it was overcome. And I said, no, we're agreeing. So we're stipulating you don't put the findings in, because there's been no finding that the natural parent doesn't act in the best interest of the child. So as an attorney representing a legal parent, I would never let somebody put that in if you stipulate. I mean, you're stuck in the 109, 119 if you want to modify.
Right.
You can modify one, but it's not as high a burden as it is if you're starting fresh in 109, because it does go through the factors again. It's just like a regular modification, like for parenting time. It kind of falls under that. It's in the best interest of the child at that point. Once a third party has parenting plan, visitation or custody. If you want to change custody, it's a substantial change in circumstances. So once you have your judgment, it kind of goes back over to the 109, 107 standards to modify.
Right.
Does that make sense?
Yeah, makes sense. But I want to make one thing clear, or ask you, this is different than a parent losing the parental rights. They're not losing parental rights, are they?
No.
If there's third person custody.
No. And that's what people make. Okay, first of all, the only agency in the state of Oregon that can terminate your rights is the Department of Human Services. They're the only ones that can cut your parental rights, unless it's an adoption. But if you agree to an adoption, obviously your parental rights are terminated. Right. But the court, unless DHS is a party, cannot terminate. You can't even give up your parental rights.
Right.
In a custody case. So third parties can't get you to give up your rights either. It doesn't work that way in Oregon. You can stipulate, like I said, you can stipulate to give somebody custody, but it's always modifiable in the future if there's been a substantial change of circumstances. Because I've had people agree to it that weren't in a good place to take care of their children. You know, they were living shelter to shelter, and the child living with the grandparents who had been living with the grandparents, and they tried to take them back, and then they fall off the wagon again or whatever. So the grandparents go, okay, give me custody. And so they agree to custody of the grandparents. But then to modify, they have to do substantial change. And I mean, but it doesn't mean they weren't, to me, they were acting in the best interest of the children when they gave up custody.
Yeah, exactly.
So you can't, that's why I'm saying in a presumption way, I would never put that in a stipulated judgment. And the judges shouldn't allow it.
Yeah,
but
I like that. Wow.
Because only the judge can make a decision.
Well, Gina, we have blown through 30 minutes. This was so interesting.
Yeah.
It does, to me at least, say one thing pretty clear, is that you really do need an attorney, because there are so many, not just obstacles, things you can do wrong, things you can just make a mistake, and it just, takes you down the wrong path, and then you don't get what you want.
And you can get attorney fees. So that's another thing people have to be aware of. If you even voluntarily dismiss a petition, the other party, you need to stipulate to a dismissal. And I have done that too, because the woman was, we talked to the children, the other attorney and I sat down with the children to get their take on it. the grandchildren. And I had to tell my client, you're not fighting the parents, you're fighting the children. They're
Yeah.
saying they want to go along with what their parents say. So, we can go to the court, but the court's not going to overcome what the children say because they were old enough to testify at the time. They were
Yeah.
like 11 and 12. So, and that's another thing you have to be aware of, who you're really arguing with.
Yeah.
I mean, parents can be very influential over their children, and their children can really believe what they're hearing. So all of a sudden parents can break relationships up with other adults if you just say bad things about those adults. It doesn't matter who it is. It's sad because I'm of the church that the more people that actually love your children and want to take care of your children with you and help you, you can't go wrong. Whether it's a step parent, and I think a lot of parents lose sight of that when you're angry and somebody's trying to get custody of your children, it's because you've cut them off.
Yep.
And that's why you have to really prove the one factor, like I said again, is you have to keep in your mind the circumstances are detrimental to the child. Because I think if you can prove that, I think most judges will give you visitation or custody. Because it all comes down to the children, and it goes to the best interest standard at that point.
As it should be, as it always should be. It's always that best interest of the kid.
Yeah.
So thank you again today.
Thank you.
It was tremendous, and you made it very complex, which it is. You made it understandable, even for someone like me. And that is a great thing to do. So again, Gina, thank you so much for being here.
You're welcome. No problem. I love talking about it. I've been doing this for 10 years. So my one case was back in 2014 when I went to the appeals court. I actually argued before them.
Oh my gosh.
Yeah. So it's kind of fun. It's my only case I've argued. I don't do appeals. So it was fun to win against okay. I don't know if you know who George Kelly is, but he is like the go-to guy for appeals in family law. So my boss, when he goes, you have nothing to lose. Your clients already have custody. It's most likely they won't reverse it, the judge's decision. I said, okay. So I prepared and I argued. And now they did ask babysitting. That's come up a couple of times if you're the babysitter. And the appeals court asked me, could a nanny have a child-parent relationship? And I looked them straight in the face and said, yes. But I don't know any nannies in their right mind that would sue for custody. Against people that pay them to take care of their children. But if you think about it, if a foster parent who is paid to keep your children after a year can have a child-parent relationship, why not a nanny? The nanny's taking care of your kids more than you are. They're with them all the time, except for when they're sleeping, like most parents. So I said yes. I said, but I can't imagine a nanny suing for custody at all.
I like that. Oh my gosh. Well, gosh, I wish we could talk a lot more. And maybe we'll do another one on appealing cases. That would be
that'll be fun. But I've only done the one appeal. I'm not the expert.
It's more than a lot of people. Yeah. So everyone else, thank you so much for joining us today as well. If you have any more questions, totally feel free to ask on this site, call us, we can get you connected. And until next time, everyone, stay safe, stay happy, and be well.